This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
Now we're going to go into our question and answer period. Okay, so the first question is, how do you record minutes during an executive session? What needs to be included and what should not be included? So executive session minutes are treated exactly the same way as regular board meeting minutes, except it's a totally separate document. So you're going to have the name of what type of meeting it is, an executive session, the date, the time, the location. Basically, you're going to be listing what was decided by the board during the executive session and whether or not there was a quorum at the meeting and when the meeting adjourned. So how do you record the executive session meeting minutes? Exactly the same way that you do the regular board meeting minutes. So if the secretary's taking minutes or maybe the manager, they're just going to do the same thing for the executive session that they did for the regular board meeting. So what needs to be included, what should not be included? Everything's included. Because remember, the executive session meeting minutes are not disclosed to anybody other than the board. So everything that we need to make a decision needs to be placed in there. And those minutes will not be released to owners who are not board members. Okay, the next question. What are the rules regarding process servers and gated communities? So you may want to take a look at, there's two laws for condominiums and planned communities that talk about 33-1262 for a condo, and planned communities are A.R.S. 33-1819. It kind of goes over what are the rules for process servers and gated communities. From my perspective, associations, shouldn't be withholding access to an officer of the court. Process server is considered an officer of the court. They should be allowed to go back and do the business that they need to do in your community. And this really only comes up with gated communities, but they should be checked in just like any other resident would be checked in. The information regarding their business and their license should be taken down by the manager or by the security guard, depending on who is looking at it. And they shouldn't be allowed to do a stakeout or anything like that. It should be go back, do your business, and then leave. Okay, and again, the two statutes, if you want to do more of a deep dive on this, for condominiums, it's A.R.S. 33-1262, and for a planned community, it's A.R.S. 33-1819. So planned communities, 33-1819. Okay, next question. Given open meeting law in Arizona pertaining to avoiding unintentional quorum of board members, is it allowed for a quorum to attend a committee meeting and not constitute a quorum? So can they take off their board member hats when they're serving as, committee members? So here is my suggestion on this, is if you have a quorum of the board attending a committee meeting, it really just depends. I mean, I don't necessarily agree with your manager who says, yes, I actually agree more with you, where I would say, no, this isn't a good idea. So if you're going to have a quorum of the board attending a committee meeting and a quorum of the board attends to participate during the committee meeting, it needs to be noticed as a board meeting. And what you could do is just notice the committee meeting and then put an asterisk saying a quorum of the board will be present. So therefore, we're also noticing this as a board meeting. I suppose you could have a quorum of the board at a committee meeting and an agreement that the board members, not, less than a quorum, will be allowed to talk. And maybe the person that would make a quorum doesn't say anything, but that's really kind of iffy. And I would advise against that. Okay, next question. How to best handle a homeowner who feels as though a specific common area, tree grove, is their personal area, whereby this owner tries to direct various landscaping and tree pruning as done by the board and community manager. Okay, so I think a good way to handle this homeowner would be just to remind them, maybe give them a copy of the plat and say, okay, this is your property and this is the association's common areas. While we welcome your feedback, the board ultimately makes the final decision regarding how these areas are landscaped. Next question from one of my favorite clients. When we conduct our board meetings, we go through the agenda and then open up the meeting for members' questions. If the ensuing questions are discussion do not result in board action at that meeting, do they have to be memorialized in the board meeting minutes? So great question. So do members' questions and the board's response to the questions, do they need, and they don't result in board action, do they need to be in the minutes? No. The only things that are required to be in the minutes would be that the board took this action. So motion, second, discussion, vote. What you could do is you could just put that there were 8 members who asked various questions and the board provided answers to those questions as best they could. That would be fine in the meeting minutes, but you wouldn't even have to put that in there if you didn't want to. Next question. As a board member, what can we do about a rogue member? He's using his position to give violations to neighbors. As a board, we've tried to stop him. He just contacts the management company and turns in violations without the board seeing them. Okay, so I'm assuming this rogue member is a board member. Maybe it's just a homeowner, I don't know. But so if this rogue person is a board member and they're just, telling manager, send out a violation letter, fine this person, whatever, I think your board needs to talk about this at a board meeting and give direction to the manager in terms of how violation letters or how fines are processed. And if this is a concern, the manager should only take direction from a majority of the board at a board meeting, and that should put an end to it. If this rogue member is a homeowner, again, just having a procedure in place so that the manager knows when and when not to act, I think is going to be really helpful for your community. Next question is, do you have suggestions on how to deal with 30-minute notice of director motion? So no time to discuss or review. So I'm not really sure in the context that you would be using this, but maybe I'm guessing right before, they don't give you any notice and then, they want to make a quick motion and there's not enough time to discuss or review something. I think really the best way to handle it is for the board to say, hey, this is a new topic. I think we need a little time to digest this. I think we need to do a little more research. And we're not prepared tonight to make decisions on this. So we're going to put this off until the next meeting. So table this and we'll discuss it at our November board meeting. I think that's probably the best way to handle it. But recognize that if you have a majority of a quorum that's ready to move on this, they're going to be able to make a decision at that board meeting. One thing you may want to look at is if it's not on your notice of meeting agenda as a topic that's going to be discussed, it may not be something that you can discuss unless the members are notified of it. So you may want to take a look at that. I don't know specifically what types of things you're voting on, but like amendments to the bylaws or the CC&Rs, those would all need to get 48 hours notice to the members. So you might want to take a look at that. Next question. When does the 48 meeting notice start? When notice is posted, when notice is mailed, or after estimated receipt of meeting notice? So we're talking here about regular board meetings. So when does that 48-hour meeting notice start? It starts as soon as it's posted, whether it's posted on your website, on your common areas of your association, when the email is sent out. It's not reliant on the owners actually opening the email or opening their mail. It's when it was actually sent. So I find that most boards don't mail 48 hours notice of regular board meetings to owners. That's just not something we really see very often. Most of them are going to be posting it, putting it on email out to the members, putting it on the website. And as soon as that is sent or placed in those areas, it is when the 48 hours notice starts. Next question, we're on question 9. Does Arizona law require anything in regards to HOA insurance? I noticed there isn't a section on insurance in our CC&Rs. So great question. So we have a cheat sheet on this topic, which my office is telling me they already provided to you. So A+ office, thank you very much, Morgan and Yvonne, for being so on top of it. For those of you who may be interested, who are listening in, and this isn't your question, on our website at mulcahylawfirm.com, we have a great cheat sheet called Insurance. And it kind of outlines the different types of insurance that associations are required to have under your documents, and typical insurance that most associations have. If you don't have any requirement for insurance in your documents, as a baseline, and it looks like our firm's sharing the cheat sheet on insurance right now. So thank you very much for doing that, team. The most common types of insurance that associations should have would be like premises liability insurance, directors and officers insurance to protect the directors and officers should they be sued for any decision that they'd be making. As an officer or director in the association, you should have a fidelity bond, which covers the association in the event that there's some sort of fraud or misappropriation of funds. Those are really the three types of insurance so premises liability, directors and officers, and then a fidelity bond. Arizona law does have some information on insurance. It's in the Condominium Act, and I don't know if you're in a condominium or not. But our cheat sheet on insurance has the links to those sections in the Condominium Act. And the Planned Communities Act, interestingly, does not have anything on insurance in it. Next question, question 10. Can a board member be part of an executive meeting if he is part of a complaint? He is the person complaining. Should the board be discussing this at executive session, or should it be at the open meeting? Okay, so I don't quite know what the complaint's regarding, but if it's a violation or a delinquency, it certainly can be done during an executive session. And I don't know if this board member is part of the complaint. It sounds like he's just complaining. Maybe it's about like a neighbor's violation or something. I mean, as long as this person is, reasonable. I mean, because I'm a board member in my community, and there are times that I will text or I'll email our manager and say, hey, can you look into this violation, right? And I mean, I don't have any bias or, anything like that. I just feel it's part of my job as a director to notify her if there's something that's broken. And so I think it really does depend on the situation. Like, let's say the board member is fixated on, a issue with a homeowner and they've almost lost objectivity. Well, in that case, then maybe we do need to tell the board member to take a step back and, maybe they recuse themselves. It really just depends. But in most cases, I'd say, no, they should still be allowed to vote as a board member as long as they can be objective and as long as they can be fair. But if they're, man overboard, so to speak, and they can't be objective or fair, you should have your attorney write that board member letter and suggest that they recuse themselves or not be present for any discussion on this issue, going forward. What about board meetings that are held by email and decisions being made by unanimous vote of the board? Okay, so we talked a little bit about this in our presentation. The only time that a board can have an email board meeting is when there's a true emergency and you can't wait 48 hours to notice the meeting. That's the only time that there's a loophole for you to have a board meeting by email, okay? And just a quorum of the board could make a decision in an emergency circumstance by email. As I said earlier in the presentation, use of unanimous written consent is not advisable based upon the two decisions that have been decided in Arizona by administrative law judges who have said specifically that association boards that use unanimous written consent, even if it's in your bylaws, is a violation of the Arizona open meeting law. So be really careful. And I still see this, surprisingly, I still see management companies telling boards it's okay to have a unanimous consent on, a decision if it's not an emergency. And I think that is contrary to, the open meeting law and those two administrative law judge cases. We're on question 12 right now, and I'm just going to give you a count of how many total we have. It looks like we have about 31 questions. So question 12 is, I'm on a board of 3 people. The president has been on the board, sometimes by herself, for over 20 years. She has brought on others to the board during this time. I'm being categorized as a gadfly. That's critical because I'm critical and problematic. I have strongly suggested that we have a board boot camp because the meetings are really dysfunctional and ineffective. Our meeting times are inconvenient for homeowners. How do we move forward and be transparent? Okay, so you're one of three. So you need to start working on the other board member or maybe your management company to just start talking about, hey, I'm feeling like things are really dysfunctional on our board. And I think it would be helpful for all of us to have a boot camp where we talk about issues and, maybe that the president, let go a little bit. She's been on the board for 20 years and maybe we start looking at some opposing viewpoints and doing things differently. The reality here, I'm sorry to tell you, is that unless you have a majority on your board, which would be two people, thinking that you need it, you're not going to be able to have a boot camp. Maybe your manager can strong arm the board to do it, but it's probably doubtful that that is going to happen. So, what I would do is try to run a candidate against the president who is more like-minded like you. If it's really a problem, maybe have a removal petition for the president. If there's really just cause why this person needs to be removed, although the removal statute doesn't require it be for cause, but I think people are reluctant to sign that unless there actually is a problem and they think that this person does need to be replaced. So hopefully those are some tips that can help you as you navigate this difficult situation. Next question. If the board members are friends and a quorum of these boards or friends are meeting, if no decisions of the board are being made, does this fall under the definition of an open meeting requiring 48 hours notification? So it's okay for a quorum of the board to meet as friends, as long as you're not discussing association business and as long as there's no decisions being made. Next question from my very favorite Packer fan. Our governing documents were created by the developer in 2002. And the language contained therein indicates that flagpoles and presumably flags are not allowed. As a veteran, I would like to install a flagpole on my property in my planned community and proudly display the American flag. Are you aware of any federal or state statute change that would be applicable? Okay, I know this particular person who asked the question because like I said, he's a fellow Wisconsinite and Packer fan like me. And so we have a cheat sheet that this person should go to, our top 10 cheat sheet where we talk about flags. If you live in a planned community, you are entitled to have a flagpole on your property. And so you should be able to submit an architectural application form and you should be able to install a flagpole on your property. And that the statute under Arizona law for planned communities that says this is 33-1808 and for condominiums 33-1261. Now, in a condo, it's a little bit different. You can only, hang the flag off of your limited common element area. So keep that in mind. Next question. Do executive minutes need to be approved at the next executive board meeting? Also, where do executive minutes need to be stored? The secretary home or association office? So yes, the executive session meeting minutes need to be approved at the very next executive session after that board meeting. Where do we store them after they've been approved? Really anything goes, but it needs to be with the corporate records of the association. So I'd prefer if you had these records electronic so that, they're not lost, but it could be kept in a binder at the secretary's home. They could be kept at the association's office. It really just depends. Multiple people can keep the records too. Question 16, what constitutes items or topics that require a survey of the owners? For example, we're changing our rules and some of the board believes we need input from every homeowner by notifying, sharing, and getting input. Others of us and the manager believe it's a discussion and vote by the elected board since it's been notified in the agenda and the homeowners for months now. Follow-up question is that the same board members believe other items like painting, lighting in the community should also require a survey of the members. Okay, so this is a pretty classic example of, some board members wanting to take it to the people on everything and some board members saying, listen, we're complying fully with Arizona law. We're noticing this in our notices that we're discussing this. And if they had a true interest, they would be coming to the meeting and giving us feedback. Honestly, there's really no right answer on what constitutes an item or topic that requires a survey of the homeowners. What I would say is if it's a really controversial topic, you should be surveying the homeowners. But if it's something that's not controversial, then I think just putting it in the meeting notice and discussing it at an open board meeting is, sufficient. Next question. We are in the process of amending our community's documents. Should we include a statement indicating virtual meetings are acceptable for conducting association business? Yes, great idea. Definitely, you should do that, because I think this is going to be a change that goes forward in our associations. I think the pandemic forcing us to have virtual meetings is going to change how associations do business in the future. Okay, we are on question 18 out of 31. So this question is, let's see, when a meeting is held via Zoom or other such conference, what is the board's responsibility to make sure that homeowners have access or know how to work such applications to be able to participate? We recently had a meeting by the board, and many homeowners could not attend or participate as they did not know how to work the features, and many logged on but could not comment or participate as they didn't know how to work the chat and raise hand options. Okay, so, what I would recommend is, if you're using a virtual platform to have your meetings, everybody has a phone, so people can dial into the virtual board meetings. So, I would say everybody should have access to this. But there is kind of a learning curve on Zoom, and most of us transitioned pretty easily on this in March and April of 2020. You could send out YouTube videos on how to participate in a Zoom meeting. You could offer to have your manager or board member, do a short tutorial for these people that need help. I would make as much resources available to them so that they are aware how they can participate. But ultimately, if there's a technology challenge, getting them the meeting minutes shortly after the meeting is a successful way to keep them informed, or showing them a video of the meeting after the fact. That's also another good way to keep them informed. So bottom line is, do they have a responsibility to do this? Well, no legal responsibility, but you should try to make your best efforts to help everybody so that they can participate if they want to. Next question. If your board is composed of only 3 members, they can't even talk to each other between board meetings, since 2 members talking to each other would represent a quorum, correct? That's correct. If you're talking about association business and you have a 3-member board, 2 of you talking about association business is going to constitute a quorum and is going to require you to notice the meeting. Next question. Our board is all snowbirds except for 1. They are gone 7 months of the year. We're self-managed and they don't always reply to concerns. And they tell us, wait until we return. We only have 1 meeting each year, an annual meeting. I have failed gutter, water damage from that, and a roof leak that needs repair. Other owners are ignored. How do owners proceed to preserve our property? Okay, this is a problem. Just based upon what you're telling me, your board should be meeting more frequently, especially because there are maintenance issues right now in your community. And so what I would recommend is that when they come at your annual meeting, which will be your next, large meeting, I would recommend that you raise this issue and say that you're concerned that there's no response in a timely manner, and try to get the board to have meetings quarterly or monthly if they're willing to do that. They may not be. And if they aren't, maybe it's time to get a new board, where they are more people live on the property or more people are willing to, do their fiduciary responsibilities to your community. So if you can't get these items that you need repaired, like the water damage and the roof leak, you should be sending the board a letter saying, if you don't do this, I'm going to take legal action. And then if they continue to fail to do it, unfortunately, you're going to have to take legal action. Okay, next question. Do serial discussions about board business among fewer than a quorum of members violate the open meeting law? So if you have fewer than a quorum discussing association business, it's not a violation of the open meeting law. Next question. We have lost valuable archived information from one management company to another and one board to another. What is the best process from losing this information? An example of this would be a warrantable item that was repaired under warranty because no knowledge of the warrantable item was transferred or questioned by the next board. Okay, the best way to keep from losing this information is really to have all of your records in a digital format. That truly is the smartest thing to do. And then, making sure that that digital format of your records is transferred whenever you're changing from, new management company to new management company, or as board members come and go in your association. On the warranty issue, maybe you should call the company and ask for a copy of the warranty. That might be a way to recreate the information on that. Next question, how much detail should meeting minutes include about votes? Who proposed, who seconded? Should they reflect who voted for and who against, or just a tally of the result? I think best practices would be, to include who made the motion, who seconded it, that there was general discussion, and then only if someone on the board requests that there be a listing in the minutes of who voted for or against, put that in there. Otherwise, it's just the motion carried 5-4 or whatever the issue is, and you don't have to list the names. But if somebody on the board wants the names in there for the actual vote count, the board should do that. Next question. In regards to annual meetings, what do you mean by a quorum for the ballots? A percentage of the homeowners? Okay, really good question. So in order to have your annual meeting, you need to have a quorum of the owners present in person or by absentee or mail-in ballot. So let's say that your quorum for your association is 25% for your annual meeting. So that will be in your bylaws, typically under the quorum section, under, annual meetings or meetings and members. And so in order to get, let's say you have 100 homes in your association and you have a 25% quorum, that means that for your annual meeting to move forward and for business to be conducted, you'll need to have 25 owners, and it's typically one vote per lot, attend in person or by absentee or mail-in ballot. Next question, why can't the annual meeting notice be sent out by email to keep our costs down? I totally agree, but it's the law. The law says that the annual meeting notice needs to be sent by U.S. mail, or you can hand deliver it. So if you want to keep the cost down, hand delivery would be an option. Problem is, what if you have offsite owners? You won't be able to hand deliver it to them. And in those cases, you might just want to mail it by U.S. mail to those offsite owners and then hand deliver the rest. But I will tell you that truly, most associations have the notice sent by U.S. mail to be in compliance with Arizona law. Next question. We meet quarterly and have used email approval for architectural requests. Then we add them to the next meeting for like an approval after the fact, or, approval, of the decision at a later time. That way we can respond quickly to people's requests. Is this legal? It just depends on what your documents state, but I think most associations, frankly, are doing it this way. So their architectural committee is, making decisions outside of a architectural committee meeting. And they can do that because they're not a regularly scheduled board, right? Regular scheduled committee meeting, excuse me. And then at the next board meeting or at the next architectural committee, they read into the record what was decided outside of the meeting, and then, everybody approves those formally after the fact in the minutes. So I think that's fine if that's what you'd like to do. Now, if your architectural committee meets regularly, however, you would need to notice that and make that an open board meeting, open architectural committee meeting, and then you wouldn't be able to make those decisions by email, because you're required to follow the open meeting law if you have regularly scheduled committee meetings. Okay, we're on question 27. We have 31 questions total, so we have about 5 left. It looks like we still have a large number of you still listening in on the questions, so that's great. The next question, let's see, are we not allowed to send out notices of annual meetings and ballots on email? We send invoices and other meeting notices and agendas in this matter. Kind of along the same lines of the prior question, just the law requires it to be sent by U.S. mail, or it requires it to be hand delivered, the annual meeting notices. So, you have to do it that way. Next question, in an open meeting, should all questions be held until the end of the meeting or be addressed at the end of each agenda topic? So really, it just depends. I'm guessing you're saying questions from the owners. Here's the only time that owners are required to be allowed to speak at an open board meeting: before the board takes formal action on something. So if there's a motion to approve something or take a certain action, there's a second. During the discussion period, if an owner wants to talk during that time period, the board has to allow a reasonable number of owners for or against an issue to talk. So if somebody has questions, you could have those questions be handled during the homeowner forum if your board's doing that, either before or after the meeting. But they don't have to be addressed after each agenda topic. Like I said, the only requirement is to have, members be allowed to speak before the board takes formal action on something. Okay, last 3 questions. Isn't there value in providing information in minutes about discussions concerning matters, particularly where there's a diversity of opinions, so that homeowners who are not present have a sense of what facts or viewpoints the board has considered? So I think there is some value to that. However, it's really not required. So your board just needs to find a balance between, putting enough information in there that homeowners can be informed versus not so much extraneous, unnecessary information in there that it's becoming a book. So it's a balance. Now, if you ever have a board member that says, I want my viewpoint in the minutes, then of course you should put that in the minutes. Next question. When should the board adopt a resolution as opposed to making the topic part of the rules and regulations? That's a tough question because it really just depends on how broad your rulemaking authority is in your document. So if you have broad rulemaking authority and this is a topic that should be in the rules, then put it in the rules. If it's, a resolution, where it's not something that would be traditionally covered by a rule, then, call it a resolution. But really resolutions are becoming pretty outdated. Most associations are, want to keep it formal record of the association. They talk about it in minutes, or they pass a rule or a regulation on something. Okay, the next question is the last question, and this is kind of more feedback for me, so I'm going to just reread the question that was asked. Can you clarify email decisions by a quorum of board members and why that's prohibited? So sure. So remember we talked about the open meeting law, and anytime a quorum of the board is discussing association business, it needs to be an open board meeting with 48 hours notice to the members. So if a board is making decisions by email, members can't see the decision-making process, they can't see the vote, and therefore that would violate the open meeting law. Remember, we said that the only exception to this would be in an emergency circumstance where the board has to make a decision and can't wait 48 hours. In those circumstances, it's my opinion that the board can make a decision by email on, emergency votes. The next part of this question is, can you recommend how to handle board member response to individual homeowner emails? Just be really careful on that, because if homeowners are individually emailing board members, if the board member responds, it really looks like that board member is talking on behalf of the entire board. And so I would really prefer if board members don't individually respond to owners. What you might want to do is respond that, hey, thanks for your email. I'm going to forward this to our community manager or the president, and one of those 2 people will respond on behalf of the board. The follow-up on this question was that our president of the board has directed other officers to not respond to individual owner emails. I agree. I think that's a good policy. And I support that. I understand the decision on that. The next part of this question is clarify that responses to owners are appropriate, but what cautions you would recommend. Okay, so this person who's asking the question wants me to, agree with them. I don't necessarily agree with that. I think that whoever responds on behalf of the association should have the support of the board. And so typically the manager or the president should be the only 2 people that are responding to emails from homeowners. Maybe it's just the manager. Also, one thing that they asked me to cover in this question is, what if the board uses a reply all function and they copy a quorum of the board, and then everybody's replying all, and it turns into a discussion via the reply all function on the computer. Be very careful on that. That's a violation of the open meeting law. So anytime a quorum of the board is using the reply all function, and a quorum of the board is on the reply all as their addresses, you potentially are violating the open meeting law. Thank you so much, all of you, for being here today for our 10th class of our 2021 virtual HOA and Condo Academy. I'd like to take this time to thank again the different neighborhood service departments from around the valley who make these classes possible. So thank you for partnering with our firm to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. You've been great teammates, and we appreciate your continued partnership with our firm to provide these free, amazing virtual classes to many residents, in your respective cities. If you'd like more information on these classes, please visit our website at mulcahylawfirm.com and click on the seminars tab. And don't forget, we have classes in November and December via our 2021 virtual HOA and Condo Academy with the neighborhood services departments. So be sure to check out those classes on our website as well at mulcahylawfirm.com. We have 2 classes scheduled for November and 1 class scheduled for our end of the year class in December of 2021. So have a great week, everybody. Thanks for joining us here today. We appreciate you being here, and I look forward to seeing you again virtually for our classes over the last few months of 2021. Take care, be safe, and have a great rest of the week.